Commissioner Holton, are you still there?
Yes, I am.
All right, we were waiting on Commissioner Boygan. I think we will proceed. So,
I'm ready.
good morning. Welcome to day 2. We will start with a roll call of commissioners.
Most certainly. Chair Benton.
Here.
Vice Chair Boygan. Vice Chair Holton.
Here.
Commissioner Ager.
Here.
Commissioner Gibbs. Commissioner Hawkins. Commissioner Hunsinger Ryan. Commissioner Jolly.
Here.
Commissioner Overturf.
Here.
Mr. Chair, you have 5 out of 9.
Enough for a quorum, but not enough for executive session. Is that correct? All right, very well. I believe, Ms. Larson, you called our attention to approval of minutes from the January 28th.
Yes.
The corrected minutes.
That is correct, yes.
We've made all the changes requested by Commissioner Boygan.
Indeed.
Okay, very well. Would someone like to make a motion to approve those minutes?
I make a motion that we approve them.
Motion made by Commissioner Jolly,
Second.
seconded by Commissioner Ager. All in favor, say aye.
Aye.
Aye. Opposed, same sign. Minutes are approved. Although it wasn't, I don't believe it was officially on our agenda, we do have public comment period again today. We had a number of folks yesterday that we called that were not present. So we said that we would allow them to speak today if they are here. We also wanted to let you know that if you want to be part of the record today with your comment, then we will hear that. There is a section during the matters where we have a section for 510 statements. At that point in time, you will be sworn in. You will be subject to cross-examination. It's all part of the Rule 510. So if you want to make sure that's in the record again, we will make time available during the hearing for you to make your statement and we'll swear you in. If not, then you're welcome to come forward and make public comment now. So I'll turn that over to Mr. Davenport. Did I say all that correctly? Okay.
Is there any audience that signed for public comment? Was the other day would like to make their comment today? Okay. Is there anyone that would like to make a public comment? Thank you. We do have paper sign-ups. I will call them by name in the order that they've signed up. Heidi Leithwood, I believe it's Jim Bozeman, and I believe it's R. Watterson.
And while they're getting ready, we should let the record reflect that Commissioner Boykin has arrived.
And this is Secretary Larson, and just to clarify, Mr. Davenport has the paper sign-up sheet. So if you did sign up on the paper sign-up sheet, that's wonderful. But if you do want your comment again to be included in the record on any of the matters that will be heard today, you would need to wait and deliver that comment when those matters are heard. So just in case folks are a little confused.
My name is Heidi Leithwood. Is this on? My name is Heidi Leithwood. I'd like to thank the Commission for their work and thank you for the opportunity to speak. The first thing I want to do is ask that you would delay any vote until after the results of the SB 181 vote, which is happening today. I'd like to briefly mention two topics: atmospheric trust litigation and climate change, as they relate to your charge to protect the health and safety of Coloradans and to protect the environment. There are three concepts from atmospheric trust litigation that James Conca talks about in his October 2018 article in Forbes. The public trust doctrine holds that certain resources are owned by and available to all citizens equally. The atmosphere is an asset in that trust because of its importance in the stability of every natural system. The government, as trustee, has a restorative duty, which means not just preventing future damage, but repairing past harms. As you consider peer-reviewed studies on fracking and its effects on health and safety, please also consider the science on climate change in the recent UN report. Climate change is already threatening our health and safety. The book Uninhabitable Planet by David Wallace Wells reports that it is not just about the coast or the tropics, it will affect everyone. I'm inspired by the work of 16-year-old Greta Thunberg, just named Woman of the Year in Sweden. She began the Youth School Strike for Climate, which now has tens of thousands of students striking in hundreds of cities around the world. You can find her famous speech to the UN online if you haven't yet seen it. One of the powerful things I've heard her say in response to the idea that young people will save us is that young people will not save us because by the time they grow up, it will be too late. According to the UN climate report, she is right. Many rules may need to be changed in this fight, but even under the current rules, you are charged with protecting the health and safety of Coloradans and the environment.
Ma'am.
I urge you to interpret that charge to mean you are charged to protect us from climate change. Thank you.
Thank you, ma'am.
Mr. Bozeman? Mr. Watterson or Miss Watterson?
Thank you for the opportunity to address the commission this morning. We all are concerned about.
Sir, may we have your name, please?
Yes, Russell Watterson. We're all concerned about the our climate and all of those things that affect it. And certainly there is an effect from oil and gas. And however, when I was in college, I took a geology class, and I found out the climate has been changing for 2 billion years. And there are times when it's good for the habitation, and there are times when it was bad. Those times that were bad had dinosaurs, and they didn't have very many humans at that time. Nevertheless, we all want to see solar work. We all want to see wind work. I'm one of those who believes in that solar is going to be good. However, this is not the time when it's going to take over. I have solar on my house, and that provides 70% of my energy, not 100%, because the wind doesn't blow and the sun doesn't shine every day. And that's why I need the other 30%. I'm also a mineral owner in Colorado. And I've owned those minerals since 1978. And the effort that's going on now is going to try to take those mineral rights from those of us who own those, and those are property rights that have been in the law since the 1870s. So I come before you to say that if we compare what's happened with marijuana, with alcohol, and with other public safety issues, then maybe we ought to see what's happening with marijuana in our state and alcohol, and compare that to what's happened with the oil and gas industry and how it affects human beings on this earth. Thank you very much.
Thank you.
Neil Ray and Cindy Bargle.
My name is Neil Ray. I intend to make a 510 statement on a docketed matter before you today, and I thought we were going to be a little later.
Yes, if you want to make it on the record?
Yes.
Yes, then you would show up during that period of time, during that matter in the docket. So which matter is that?
It is number 181000799. I believe it's a protest by the wildgrass community.
Yes.
Application
So-
by extraction.
Yes, so during that, as far as final hearing order, there is a section in there that allows for 510 statements. If you could stick around, that would be great.
We will.
And then we will swear you in and you'll be part of the record.
Thank you so much.
Thank you.
Thank you both.
Vivian Weinstein.
My name is Vivian Weinstein. I'm a 77-year-old lady, a citizen of the city here for 5 years and 8 years in Colorado. I've been here many times, and I've spoken before this commission many times. I wanted to make sure I was counting that all the commissioners were here. And I'm just going to speak on one issue at a time. I sat here, I'm a registered nurse. But that didn't really help me. I did some studying and I did my homework, more than a lot of people my age do, and on the climate. So I understand a bit about what's going on in Colorado here with the gas and oil. We have 9 commissioners here. And I looked at them, and 6 of them directly are industry related. One is a mayor, I'm not sure who that is. One is a mayor and a scientist, but also related to oil industry and worked in the oil industry. I don't feel like there's anybody here, that hears, and we're all off record, so you can walk out of here and everything says. I don't know that's possible. But I don't think that after listening to scientists, nurses, doctors, and teachers, educators, all kinds of people that have come before this commission, and I have sat here and listened for the last 4 years, since I've been in Denver, come to these meetings. I've made just about every one of them, just maybe one. And I've never felt like you're really hearing us. There's never a response. And the response basically is that you have, that you give all the permits that are requested of you. So I don't feel like you're represented all, that the people of Colorado are represented all, or people who have a different opinion than the Osprey are represented all. I mean, it's a drastic move to change the representation on this commission for to have a fair hearing about how to use energy in the future in this state for the health and the welfare of the people of Colorado. Thank you.
Thank you, ma'am.
Mr. Chair, I don't have anyone else on sign up for public comment.
Very well. Is there anyone who walked in late and would like to make a comment? Okay. We might be a little too early for a break yet. No, you're okay. All right. Ms. Larson?
Yes. The first matter that you have before you today is docket number 181-000799. It's the matter of Extraction Oil and Gas, Inc. And Mr. Michael Eden is the hearing officer on this matter, and he will introduce it for you.
Very well. Mr. Eden?
Good morning. Thank you, Commissioners. In this matter, Extraction Oil and Gas has filed an application to pool all interest in an approximate 1,600-acre drilling and spacing unit for the development and operation of the Niobrara and Codell formations, and to obtain cost recovery against the non-consenting owners in 13 horizontal wells, otherwise known as the Livingston wells. Wildgrass Oil and Gas Committee, or Wildgrass, and Affected Coloradans Together, ACT, are protesting the extraction's pooling application. At one point, Adams 12 5-star schools and Mr. Brian and Miss Tiffany Kilcoyne also protested extraction's pooling application. However, these parties have since withdrawn their protest, and Wildgrass and ACT are the only remaining protestants. Extraction filed its application on August 30th, 2018, and Wildgrass and ACT filed their protest on October 15, 2018. On January 23rd, 2019, Wildgrass filed a complaint against the Commission and the United States District Court for the District of Colorado in case number 119-CV-190. In this federal case, Wildgrass challenges the constitutionality of the Colorado pooling statute. On February 12th, the presiding judge in this federal action, the Honorable R. Brooks Jackson, issued an order that extraction's pooling application shall be heard at this March hearing. Judge Jackson further ordered that the Commission hear issues relating to public health, safety, welfare, and the environment, economics, and whether extraction's proposed development will result in just and equitable shares to all owners. On February 14th, at the initial pre-hearing conference, I instructed the parties that the case would proceed in accordance with Judge Jackson's February 12th order. On February 27th, Judge Jackson issued another order stating in part that the court does not set the agenda for the Commission's hearing, but that the court hopes that the Commission will elect to consider the environment, health, and safety issues concerning the proposed drilling that appears to be the subject of this litigation. And I believe the full text of that February 27th order is included in the final pre-hearing order. In accordance with Judge Jackson's order, I've endeavored to prepare this case such that, in addition to the determination of whether extraction satisfied the requirement of Commission Rule 530 and CRS 3460-116 governing forced pooling, Wildgrass can present to the Commission its arguments regarding public health, safety, welfare, and the environment, economics, and just and equitable shares. As you can see from the portfolio, Wildgrass requested and was granted discovery in this case. The parties disputed the proper scope of that discovery, and I issued an order ruling on those disputes. Similarly, both parties filed motions in limine and made numerous evidentiary objections. I ruled on these various evidentiary objections at the final pre-hearing conference, and the final pre-hearing order sets forth what those rulings were. The exhibits included in the portfolio are those exhibits that I admitted. There are no remaining pending motions in this matter. The parties included a list of stipulated facts in the final pre-hearing order, and there is also a separate PDF in the portfolio listing the parties' stipulated facts. The final pre-hearing order governing this case is included in your portfolio. Per this final pre-hearing order, each side has 1 hour and 15 minutes to present its case.
Thank you, sir. Should check to see, are there any commissioners that have a conflict of interest with this matter? Hearing none. Any motions or dispositions of any procedural matters? It sounds like you resolved all of those. And the stipulations are presented or provided with us in our materials, so we can proceed with an opening statement by extraction.
Good morning, Commissioners. Just as a couple of housekeeping matters, I think both extraction and Wildgrass have certain standing objections that they would like to assert. As you likely know, that this hearing has sort of taken a twist from a standard pooling hearing to something more that seems to involve spacing as well as permitting issues. And Wildgrass has raised issues related to public health, safety, and welfare, extraction's financial viability, and economics of the project, which its extraction's position, none of those items are appropriate for a pooling hearing, which is to be governed by Section 3461.16 and Commission Rule 530 to allow a more streamlined hearing. Extraction hereby would like to assert a standing objection to any argument, testimony, or evidence presented by Wildgrass related to public health, safety, welfare, economics, or extraction financial liability.
Just a moment, please. We will note that for the record. More than likely, we will go ahead and listen to that, and then we'll give that proper consideration when we get into deliberations.
Thank you. Thank you, Chairman.
Is that your opening statement, or do you have something else you would like to say?
No, but I wanted to counsel Wildgrass the opportunity to address their housekeeping matters regarding objections.
Very well.
Good morning, Commissioners.
Could
I just ask Mr. Pershala to identify himself for the record?
Excuse me. Joe Pershala, Weldon, Sullivan, and McIntooly, on behalf of Extraction Oil and Gas Inc.
And thank you for correcting that part for the record. So if you please identify yourself before you speak.
Good morning, Joseph Salazar, on behalf of Wildgrass and Effective Coloradans Together, along with Kate Merlin. Thank you very much, Commissioners, for this opportunity to present in front of you today. We do have a few standing objections. Number one is we've spelled it out in our pre-hearing statement that we don't believe that the Commission has jurisdiction to hear this matter in the sense that when we're talking about hydraulic fracturing of shale, that doesn't apply to the rule of capture in which the Colorado Oil and Gas Conservation Act is grounded. As we know, there are cases all across the nation that are now starting to come out from state district or state cases to federal cases where courts are seeing that non-transient minerals such as shale don't apply to the rule of capture, like those minerals that go from one person's property to another person's property. And so they're saying that the rule of capture does not apply in the situation. That's what's happening here. So we have that briefed in front of Judge Jackson now, and we said that it was highly persuasive. So that's our first standing objection. Our next standing objection is on the issue of time. Judge Jackson was very clear in his statements in the court that he expected that would be given a full and fair opportunity to present our case. An hour and 15 minutes is not a full or fair opportunity, particularly when there have been thousands and thousands of documents presented in the record. We alone, just after looking at the extractions, documents and exhibits, we alone have over 1,300 documents. So we have a standing objection on the time limit. Number two is that extraction hasn't even met the procedural burdens with respect to the notice. They have provided, and we have evidence of it, that they have contacted some of the mineral rights owners and only provided them 35 days instead of the 60 days as required by law. And until they meet that procedural burden, I don't see how the commission should be able to move forward. Do we have some of those up right now? Okay.
Chairman, I think
So in the July offer, July 17, 2018, there was notice sent out by extraction to individuals that they had 35 days. It says right here, if you do not return your signed elected page and AFE within 35
Chairman,
days.
if I may interrupt.
Excuse me a moment, Mr. Salazar, go ahead, please.
I think we're getting far afield here. The purpose of this housekeeping was just simply to assert standing objections. Now we're getting into the merits of this proceeding, and I think there's going to be fair opportunity for Wildgrass to make these arguments in the procedure that's laid out in the final case management order.
Fair enough. Mr. Salazar, keep it short and list them out, and you'll have plenty of time to talk about them later.
That's fine. Yeah. And then our last one is on discovery. Judge Jackson was very clear that we had the opportunity to take a look at the economics of the company itself, and we were limited to only public accessible documents. It's not what Judge Jackson had said. So we're going to use that as a standing objection.
That's it?
That's it.
Very well. Duly noted. We also have that opportunity to present, and we'll take it into consideration. I guess now we can proceed with opening statements.
Thank you, Chairman.
Started by extraction, Mr. Pachala. Please go ahead.
Good morning, Commissioners. I, again, just want to reiterate that this is somewhat of a peculiar hearing since we're mixing so many different issues that typically aren't heard in a pooling hearing. And I think the other kind of hurdle that we're dealing with here is that the protest that we've seen is quite ambiguous. It's really just a number of bald allegations related to an unreasonable lease offer and claims of adverse impacts to public health, safety, and welfare, but we've never seen anything actually articulated from Wildgrass that sets forth really what their issues are. So to some degree, we feel like we're fencing with ghosts here. We're going to do our best to try to address these issues, but again, I think we're just kind of arguing without any real direction. So I'd like to start with just refreshing the commissioner's memories. I know all of you that are present in the room and Commissioner Halton that's on the phone were present for the spacing hearing involving this unit back in 2017, and that was October of 2017. And if you recall that this was a project that's really a first of its kind that resulted from years of work, collaborative work between the city and county of Broomfield and extraction that led to an operator agreement and a comprehensive development plan governing this unit. And that process involved not just city representatives, extraction, but also commission and citizen groups. And what we have is really a best-in-class development project that extraction is in fact right now proceeding with on the other drilling and spacing units. And all of this was designed to protect the public health, safety, and welfare of the Broomfield residents. And that of Adams County, if you recall, we also had a hearing in August of 2018 where some other surface locations were addressed. These same considerations of public health, safety, and welfare were addressed. And what was determined then was that the protections in the operator agreement also protected the citizens of Adams County. I think the other thing that came out of those that's important here that came out of those negotiations that's really relevant to this proceeding is that in the discussions with the city and county of Broomfield, there was a settlement agreement that was reached that also included minimum lease terms solely for the people of what the Wildgrass community that extraction needed to offer. And it, in fact, offered those and exceeded those offers as time went on and as you will hear. So this pooling hearing is really just the culmination of all of this
many-year process that we've been involved with. So here today, we're going to start with an understanding of pooling and Colorado pooling standards, the relevant procedural history, a summary of the parties, the protests, and the court actions, and I'll explain how those are relevant. And then we'll have a land presentation regarding the offers to lease, the offers to participate in the wells, an operations presentation regarding public health, safety, and welfare. And again, that's being done under protest, under objection, and then a very short economics presentation as well. So to start, what is pooling? Pooling is the combining of separately owned tracts within a unit to share the production and share the costs associated with that. And in the absence of voluntary pooling, we have a compulsory pooling statute. And why do we have that statute? The reason we have that statute is to protect the small mineral owners. Because when we have regulatory scheme and conservation statutes that limit the number of wells and where the wells can be drilled in a drilling and spacing unit, not every owner has an opportunity to develop his minerals on his own account. And that's why we have pooling, to ensure that each of those owners that can't drill his or her own well have an opportunity to receive their just and equitable share. And we heard it in public comment here this morning from Mr. Watterson, who's an owner within this DSU, that pooling is necessary so that he can enjoy his share of the minerals in this drilling and spacing unit. And the slide that's before you is taken out of the preeminent treatise on oil and gas law from Professors Martin and Kramer on why we have pooling. And effectively, if we didn't have pooling, then the state would, due to the conservation statutes, would be essentially taking the mineral rights of those small owners. So what are our standards to look at for pooling? Our statute is clear and our rule 530 is clear. The order must be on terms that are just and reasonable to ensure that each owner receives his just and equitable share of the production from the unit. And the statute makes sure that we allocate appropriately the costs of drilling, completion, and operations among those varying interests. Unleased mineral owners that choose not to participate, not bear the risk of the exploration, are to receive a 12.5% statutory royalty and no liability for operational errors. So then what are the preconditions that we need to look at before entering that order? And that's what Rule 530 comes in. And Rule 530 requires that an operator seeking to pool serves all owners, unleased mineral owners and working interest owners in a unit with either an opportunity to lease or an opportunity to participate in the wells. And when we look at an offer to participate in a well, the information that needs to be provided is the well location and objective depth, the estimated cost of drilling and completion, and the estimated spud date. A reasonable offer to lease is to be considered by giving the unleased mineral owner 60 days to review. You need to include the date of the lease and the primary term. These are the considerations for the commission on whether a reasonable offer to lease has been provided. The date of the lease, the primary term, the royalty, the bonus, and then other lease terms that might be relevant, such as a non-surface occupancy lease, an option period. But nothing in the statute or in Rule 530 requires the commission to consider public health, safety, and welfare in a pooling context. And those issues are considered in the permitting process. We've had these discussions before. In fact, as we'll hear later, that the commission did consider public health, safety, and welfare in the permitting process. So let's back up to the procedural history here of how we got to this place. In August to October, both the city and county in Broomfield and Wildgrass Oil and Gas Committee, they protested the spacing of this unit. This was just one of 11 drilling and spacing units that comprise this Broomfield project. On October 24th, 2017, Broomfield and Extraction executed the amended and restated oil and gas operator agreement. And that was a result of more than 2 years of work between those parties, as well as including its task force, dozens of meetings, public forums, and council meetings. The spacing hearing to establish, and then October 31st, 2017, we had the spacing hearing to establish the Broomfield drilling and spacing units. And if you recall, at that time, the city and county of Broomfield withdrew its protest to include certain language in the spacing orders that the permits would comply comport with the operator agreement. And at that time, the commissioners truly recognized that this was a first of its kind project and an agreement between a local government and an operator to cover all aspects of development. At that same hearing, the commission continued this drilling and spacing unit to the December hearing on an issue related to notice with council for Wildgrass, and it was a different council at that time. It got continued to the December hearing, but on December 1st, 2017, Wildgrass Oil and Gas Committee, which is a party here today, withdrew its protest with prejudice to this unit. And then at the hearing in December on the 11th, the Lowell South unit was approved as an uncontested matter. And at that time, it was determined by the commission that the unit would assist in preventing waste, protect correlative rights, and avoid unnecessary wells. And the commission also determined that the project was economic and that that would result in efficient and economic development of the resource. So let's fast forward to spring of 2018. The commission staff approved the extractions Form 2A and Form 2s for the Lowell South unit. The permits were submitted, as you'll hear, were submitted with all 57 best management practices called for by the operator agreement. Staff reviewed those and determined that not all of those best management practices were within the commission's jurisdiction to enforce. And so the commission staff included all of those which it could actually enforce. It also noted that the ones that weren't included were still subject to the operator agreement, and that Broomfield and Extraction were contractually obligated to one another on those items. The staff also determined that the 2As and the 2s comport with the operator agreement, and that they sufficiently protect, the BMP sufficiently protect public health, safety, and welfare. Since that time, shortly thereafter, really, Wildgrass Oil and Gas Committee filed an action in state court challenging the commission's issuance of those permits, and that matter remains pending. During the year of 2018, beginning in January, Extraction has engaged multiple times with the mineral owners in the Lowell South unit. They've sent over 6 lease offers to all of those owners in the unit and sent 2 well proposals. And those offers satisfy Rule 530. And then it was in January of this year that Wildgrass filed another lawsuit in federal court challenging the constitutionality of forced pooling itself. And that's really what resulted in this hearing being somewhat of a hybrid rather than just a straight pooling. So who is Wildgrass Oil and Gas Committee? This party that's in front of you represents 50 mineral owners in the Wildgrass community out of more than 1,100 owners in the drilling and spacing unit total. And they own collectively 10 net mineral acres. This unit consists of nearly 1,600 acres. This small fraction was formed to ensure that their interested owners had representation in their lease negotiations, and that's why they filed their initial protest in the spacing. They had that representation, as you'll hear. Now they protested based on a threat to public health, safety, and welfare, and economic development, and other constitutional issues, all that are pending in state and district and federal court. And who is ACT? ACT is a former Wildgrass resident or incorporated by a former Wildgrass resident that in the fall of 2018 acquired the mineral interests of 6 Wildgrass owners. And there's no surface ownership for ACT. ACT doesn't have any concerns regarding surface. But really, what are the goals of Wildgrass and ACT is that they really want to stop all the other owners in this unit from exercising their co-equal and correlative rights. And as we heard from Mr. Watterson, it's his interest that would be deprived here if a pooling order isn't entered. And this unit includes hundreds of individuals just like Mr. Watterson. There's also Adams 12 five-star schools that has interest in here that are leased. There's the Archdiocese of Denver that's leased. And in fact, the Wildgrass Master Association, which protested the spacing, is now leased. So the claims and issues of Wildgrass are really, other than, excuse me, whether Extraction's lease offer was reasonable, all these other claims are pending in other forums. So we look at these protests. This is the background. This is what Wildgrass Master Association protested on. Extraction's economic viability, public health, safety, and welfare, and economics of development at the time, based on market conditions. Wildgrass Oil and Gas Committee adopted all of Wildgrass Master Association's arguments in its protest in the spacing hearings. And then it later dismissed those with prejudice. And what's the legal effect of dismissal with prejudice? It means that you can't reassert the same claims in any future proceeding, even if the relief sought is different. So what you're going to hear from Wildgrass is that, well, that was spacing, and this is pooling, and it's different. But the law doesn't recognize that difference. It says that if you raise your claims, you dismiss with prejudice, that is a final adjudication on the merits as to those issues and claims, and they can't be reasserted. In fact, not only did they reassert them here in this pooling hearing, Wildgrass has asserted them both in state court and in federal court. And what we're seeing is really forum shopping. In the state court action, they're making the same claims that they are here, that public health, safety, and welfare is going to be affected, that waste and correlative rights and economics, and that the permits don't comport with the operative agreement. That's in the state court action. And in the federal court action, we're hearing that the permits were approved without consideration of the public health, safety, and welfare, that the lease offers were unreasonable, waste, correlative rights, economics, and then the constitutionality of pooling. And that procedural history is important because based on incomplete information, only hearing testimony from Wildgrass in the federal court action, Judge Jackson issued an order in fact, he clarified his order and said, really, he just hopes that you might consider these things, but doesn't say that you must consider these things. But all that he heard was testimony and argument from Wildgrass. He never even heard from the Attorney General's office. And so he was completely unaware at that time that these issues of public health, safety, and welfare, and economics, and these other matters unrelated to pooling were already addressed both in spacing and in the permitting process. And it's our position that really the court didn't require you to hear these issues, that he just hoped and a wish. So he also didn't order that the commission reach a certain outcome, and he didn't preclude the commission from finding that pooling does not implicate public health, safety, and welfare and Extraction's financial viability. It also doesn't preclude the commission from finding that economics has already been addressed in the spacing hearing, or preclude the commission from finding that public health, safety, and welfare was properly addressed in the permitting process. And I think it's important to understand that if we're going to go down the road of public health, safety, and welfare, is that this commission has delegated to its staff, who has expertise on these issues, the task of reviewing permits and making sure that the permits do comport with the Conservation Act, and that these operations do adequately protect public health, safety, and welfare. And the staff undertook that analysis. And these references that are on the screen in front of you right here are the staff's comments to the public hearing, the public comment process, at which the staff concluded that the BMPs and the conditions of approval that are applied to these permits are sufficiently protective of public health, safety, welfare, and the environment, including wildlife resources. So over this 8-month period, Extraction has made, and this is since this year alone, that Extraction has made, from the beginning of 2018, Extraction has made several efforts to work with the residents of Wildgrass and the owners in the Lowell South unit. And that's far more than what was required by the statute of Rule 530. And with that background, we would ask that the commission approve Extraction's pooling application.
Thank you.
Thank you.
Do we have a time check, please?
Yes, 57 minutes and 39 seconds.
Thank you. Whoever is, are you both planning on speaking or just one? All right, very well. Please proceed.
Thank you very much, Commissioners. Wildgrass Oil and Gas Committee and Affected Coloradans Together are nonprofit groups organized by neighbors to protect themselves and their children from extraction. They are literally neighbors who felt no power as individuals. But they did something wonderful and they formed their own powerful collective. Their mighty efforts have led us to this unprecedented hearing today. Judge Brooke Jackson of the U.S. District Court took notice that this administrative process needed to provide some fundamental due process protections, including allow these protestants the ability to discover information from extraction and to present evidence at this hearing. If our clients are not allowed to make a meaningful presentation, just as Judge Jackson warned, the COGCC will be looking down the barrel of a due process violation. I fear that Judge Jackson's order already is being watered down with the 1 hour and 15 minutes we are allowed to present our case, where there are literally thousands of documents and 9 witnesses. And even still, we were denied economic information about the company that would help our clients form a more complete picture of a company that is trying to take away their mineral rights. Commissioners, in this incredibly short period of time, protestants will demonstrate that, number 1, extraction lease offers were neither fair nor equitable. I'll show you a document straight from extraction, looking at the various lease offers that were made to the individuals within a certain geographic scope, based off of the acreage and bonuses and royalties, and there is no rhyme nor reason for the madness of the lease offers. In fact, they pretty much just throw mud into a wall and see what sticks. And thus, how can you ever come to a determination of what is fair and reasonable when things are so arbitrary as that? Number 2 is that when it comes to this whole issue of these notice offers that are given out there, there's no information whatsoever given to the individual as to what the hazards are of pulling, the hazards of fracking, the economic viability of the company. Nothing is in those lease offers that would allow an individual to consider a contract with a company. This has become quite the concern, because now we have to start asking ourselves the question about what is just and equitable, which is exactly what the statute talks about. You can't have it one way and say, well, we're going to talk about waste and correlative rights because it's in the statute, but then have it another way and say, well, we're not going to talk about what is just and equitable even though it's in the statute, or what is fair and reasonable when it's in the statute. It all has to be brought together. And you'll see that these lease offers, when it talk about just and equitable, provides no information whatsoever to those individuals who receive those lease offers about what just and equitable would be. It's just basically, here's an offer, sign it, and if you don't, you're going to get forced pooled. You're going to have witness after witness come up here today and tell you that their bargaining power was completely taken away. Exactly what Judge Jackson heard as well. Their bargaining power is taken away. And I don't know whose fault that is. Because it's not okay that one industry can go into a neighborhood and not give those individuals any idea whatsoever of the risks associated with those activities and be forced into considering a lease offer, otherwise be penalized if they don't accept it. What we do know is that, and the record will show that, before protestants were threatened with pooling, extraction willfully withheld documents related to public health, safety, and welfare and the environment. In fact, it was only through discovery, thank God for Judge Jackson, that we learned that extraction had a number of scholarly studies that raised the specter that its activities are detrimental to the public and environment. And as we know, just yesterday alone, extraction was fined $805,000 for their bad activities. You will hear testimonies today that Extraction neglected to share any of this information with these affected residents and still made these offers nonetheless. Documents from Extraction demonstrate there are concerns that its financial conditions is not capable of sustaining this project. Since I don't know what information they have to provide you in terms of economics or their economic viability for a project. But when they began this project, just before they started the project, since March 23rd, 2017, Extraction's market cap has plummeted from 2.89 billion to today's market cap of 652.8 million. This represents a nearly 70% drop. How can this company have the economic viability to complete a project that is worth more than its own stocks? There's something else too. Even though we weren't allowed the entire panoply of documents that we had requested, even the public filings, the 10K, their SEC filing from last month, you will see that they have listed in their risk factors the possibility of not being able to complete this project or other projects, their inability to be properly bonded in this matter, their inability to sustain a hit if an accident were to occur because they don't have enough insurance in this matter. And we're talking about residents. We're talking about highly industrialized activities where kids are at, and they have these risk factors. So why is health and safety an issue here? Because it's in the statute. It's permeated throughout the statute and even in your own rules. Health and safety is discussed. One could say, well, when it comes to pooling, we don't have to consider it. You have to consider it all across the board because it's in your organic statute. That's why those issues are raised. Fair and equitable, that's also in the statute too, in the organic, pure nature of the statute, which the commission is supposed to enforce. That's why that's being raised here today. And what's just and equitable, that's not defined anywhere. And that's why this part of the hearing is important, because we need to figure out what just and equitable means from a company that is that's lost 70% of its market value and is drilling on a pretty much a hamstring budget. Furthermore, this application must be denied on substantive rule violations. Extraction offered mineral owners in January of 2018 only 15 days to consider. In July, they offered 35 days. Some owners received no offer at all. We still have people who have no offer. How you can move forward when people still haven't had any offers is astounding to me. These are non-discretionary requirements that cannot be waived. They are minimum due process requirements. Furthermore, lease offers must be reasonable, and we will show you all the ways in which these offers were not reasonable, including conflicting terms, arbitrary terms, and bonuses. Despite the small amount of time given to present our case and not being provided all the information we sought, we believe the commission will find that Extraction's pooling application must be denied. Too much of their own information works against this pooling application.
I think before we proceed with the case in chief by both parties would be acceptable, I'd like to go ahead and swear all the witnesses in at once. Is that possible? Yes, Mr. Ricciolo.
Sorry, I was distracted. Were you asking whether we can swear in all the witnesses at one time?
Yes.
That's acceptable to Extraction.
That's fine.
All right. Very well. Mr. Davenport.
Could I have every potential witness for both parties stand, please? We'll start on my left. If you could just raise your hand and state your name and swear you tell the truth, we'll move to my right from there. Go ahead, please. Thank you. Thank you.
Newhall, I swear to God. I swear to tell. First, I swear to tell.
Oh.
Jason Rayburn, I swear to tell.
Thank you.
Okay. Mr. Pachala, please proceed.
Thank you. We'd like to introduce our first witness, Mr. Jason Rayburn, staff landman extraction. Mr. Rayburn, would you please state your name, title, and experience for the commission?
Jason Rayburn, landman for extraction. I've got 11 years of experience in oil and gas.
I'd also like to highlight that Mr. Rayburn is the recipient of the Denver Association of Petroleum Landmen 2018 Landman of the Year Award. Mr. Rayburn, the first exhibit in front of you, can you please describe this for us?
To reacquaint ourselves with the location of the Lowell South Drilling and Spacing Unit, this shows the outline of the spacing unit in blue within Broomfield, along with displaying the pad location for the Livingston pad displayed by the green star.
What does this slide represent?
This shows the overall participation in the Lowell South unit. The unit is comprised of 1,558 acres, with 1,355 of those acres being leased, which translates to 87%, with all 87% of that participating in the project. We have 12% of the parties that we attempted to lease were unresponsive. And finally, the Wildgrass Oil and Gas Committee and ACT protestants make up less than 1% of the overall unit.
Mr. Rayburn, can you explain with respect to the 12%, are those non-consenting, or how do you describe those?
As we'll see on the timeline that we present in the next few exhibits, these individuals were contacted multiple times during the 2018 period of 8 months. And by unresponsive, they either they have not contacted us to respond to our attempts to lease and have ignored all notices.
What does this next slide represent?
This exhibit shows the Livingston surface location relative to the Wildgrass neighborhood. The closest Wildgrass resident is 2,200 feet from the pad, again, the pad indicated by the green star. The Wildgrass Oil and Gas Committee and ACT protestants are represented by the red on the map, and the closest protestant here is shown at over 3,000 feet from the pad.
Please describe this next exhibit.
This exhibit shows the status of the lands within the Lowell South unit, yellow representing leased mineral interest and red representing the protestants. It's important to note here that in section 19, the mineral interest was severed due to previous reservations, and so half of the majority of section 19 is owned by a handful of entities, with the balance of the 50% being owned by the surface owners.
Mr. Rayburn, I think this is a good opportunity. Would you please describe the process that you use to identify the owners within the Lowell South unit?
We have brokers that research the documents related to each tract of land, from patent from the United States to the first owner. And each document related to, again, each tract of land is collected, given to a title attorney, and those lands are examined, documents are examined, conveyances to determine the current mineral owner in the unit.
Do you rely on that research in order to send out notices, leases, and well elections?
That's correct.
This next exhibit is a timeline. Would you please walk the commissioners through?
This is the timeline of our engagement with the mineral owners within the unit during the 8-month period in 2018. From January through August, we sent 6 offers to lease. 2 of those offers did contain elections and AFEs with the option for them to either lease or participate in the wells that were proposed. I think it's important to note that the final 2 were well proposals due to the change in the statute that required, previously required mineral owners a minimum of 35 days to make an election to lease or participate. And so to comply with the new rule that went into effect in January of 2019, we sent out a second notice that had a 60-day expiration period. We also have on this timeline the Wildgrass Master Association execution of their oil and gas lease in August. Also, the protest that was submitted by the Wildgrass Oil and Gas Committee in October to this statutory pooling, which did list many items, but this was the first time that we were contacted by this group. We were never, they never reached out to discuss or negotiate a lease or any type of term related to that.
Mr. Rayburn, during Wildgrass's opening statement, there was comment about first lease offer in January, only allowing 15 days to consider lease. Can you explain what those early lease offers were and whether or not they have any implication with respect to the pooling rights that you're trying to assert?
As you'll see on the next slide, the first lease offers are essentially for us to get a feel for the market. I believe we're probably the first outfit here to send out lease offers. Again, you'll see that we increase those offers over time due to numerous factors, but with respect to pooling and complying with the rule and the statute, those lease offers did not contain a well proposal with the elections or AFEs that would constitute a proper offer or an offer that is required by the standard and rules and the statute for pooling.
Thank you. You have an exhibit in front of you that is a lease offer schedule. Can you please describe this to the commission?
This lease offer schedule shows the change in our terms that were offered with respect to bonus and royalty and length of the lease over that 8-month period that I mentioned between January and August of 2018. We began our offerings at $500 as a minimum bonus and a 15% royalty. In Section 19, Section 18 was given the minimum royalty of 17% since that was previously negotiated by Wildgrass Council and the City and County of Broomfield with extraction. As you can see, over the 8-month period, we increased from 500 to 1,000 to 1,500 as a minimum bonus and ultimately landed at 20% royalty. The minimum bonus here was to cover those folks who owned less than 1/3 of an acre, a net mineral acre, so that they would receive a generous bonus in order to sign the lease. All of the lease offers that we made included no service occupancy provision. During this 8-month period, extraction did acquire lease rights to an additional 460 acres over what we'd already secured, with an average royalty of 18.07%. And in total, there were leases taken from 1,130 owners in the unit.
And you mentioned that there was a negotiated royalty for Wildgrass, the City and County of Broomfield. Did that apply to any other owners within the unit?
No, it was only to apply to the Wildgrass neighborhood.
And in your experience in the as a landman in the Wattenberg field, how does the leased bonus offer that extraction made compare to what you've seen elsewhere in the field?
I feel that the offer is reasonable and generous. Again, because of the minimum bonus we instituted here, there are individuals that own a tenth of an acre that still received the $1,500 bonus. And I think that this is typical, or lease terms in the lease are typical for the basin, but the minimum bonus is the largest that I've seen.
Thank you. No further questions for Mr. Rayburn?
Very well, Mr. Salazar, do you have any cross? Or who is? Very well.
How do we switch over?
Pardon me?
How do we switch over? How does this work in terms of the technology?
Our ACE IT person here will help you out.
Nice. Okay, I'm ready. Am I ready to go? Okay, I didn't know if the commissioner had to.
No, if this is for cross-examination, please proceed.
Okay, thank you. All righty, thank you, Mr. Rayburn, for being here. Before I get down my line of questioning, you
Just
said
a moment, please.
May I interrupt?
Yeah.
I've reviewed the exhibits that Wildgrass has provided that were admitted, and I don't believe this was an exhibit. And it looks to be newly marked, Exhibit 3B. Or, oh, never mind.
One of
Excuse me.
extractions exhibits.
Thank you.
Sorry?
Okay.
One of extractions exhibits.
One of the extractions units. All right. Very well. Thank you.
all right. Mr. Rayburn, did I hear you correctly? Did you say that the city and county of Broomfield negotiated the lease rates for these individuals in Wildgrass?
That's correct. Sorry. That's correct, along with Wildgrass Council.
Along with Wildgrass Council. Who was council at that time?
Matt Sura.
Okay. Now, sir, it isn't true that you offered this negotiated amount to everybody in Wildgrass, correct? I mean, this is Extraction's own document based off of what's called the lease tracker. And isn't it true that some individuals ended up getting $68.74, $21.20, $27.40, just as a few examples?
I think what we're hearing is that there's Wildgrass is raising objections regarding lease terms that don't affect these protestants. So we're going to object on the relevancy of the question. But
Sir?
Could we scroll over to the right? Are there dates on these?
What's your document?
Commissioner, hold on, please. Commissioner Boygan.
Can I just ask, what exhibit are we looking at?
Right.
Is it in?
It's in exhibit. It's in
Exhibit
exhibit
3B?
3.
From extraction.
Where is it? It's in the extraction exhibits.
There.
All right, go ahead.
Okay.
Hold on.
I'm sorry, when I look at extraction final exhibits and exhibit 3, there's a PDF document that's the form 2, but I don't see a 3B. I apologize if I'm missing it.
Yeah, I
But if
think
you can
it's,
point me to where I should be looking.
within the Google Drive, there was a separate folder that said extraction exhibits, and then there was exhibit 3.
Yes.
And then within that exhibit, there's this massive spreadsheet that has all this stuff in it. Here it is. Within their portfolio.
I see.
Commissioner Jolly, do you have it?
Yes.
Yeah, it's in 6. There it is, then hit that top one.
Okay. Thank you.
Sorry, folks, we had a little bit of new technology sprung on us this time around. Ultimately, I think it'll work better.
All right.
All right, hold on. Mr. Overturf?
I'm good.
You're good? Commissioner Egger?
I'm good.
All right. Proceed.
Okay, thank you.
It appears that the leases that were taken, that you're showing here, this small sample, may have been taken prior to 2018. We began leasing in the unit, I believe in 2016, even before my time with extraction. And I don't believe at that time we were offering a minimum bonus. And so that is the only thing I could think of without knowing the dates of these leases, why those would be lower.
And how'd you determine what would be offered a bonus and what wouldn't be offered a bonus?
Sorry, could you repeat that?
How did you determine what would be offered a bonus and what would not be offered a bonus?
We work closely with our engineers to determine, while they're doing their exercises surrounding economics, we will receive guidance on bonus and royalty tops for those. And as the leasing project moves along, if we need to revisit those, as we did, to increase them over time, then we again go back to our engineers and determine what that bonus and royalty looks like.
It seems like we're having technical difficulties here. We're going to turn to Extractions Exhibit L, which is emails from Jason Rayburn.
Mr. Perchala, perhaps you could point us, we have numbered exhibits, we don't have an exhibit L.
Oh, Wildgrass.
That would be Wildgrass. Wildgrass Exhibit L.
And since your exhibits had, looks like almost 1,400 pages, perhaps you could tell us what page we should go find.
It's page 741.
Thank you.
That I prepared.
Okay, well, that's up and running. Commissioners, I don't know if you're at Exhibit L or not. But Mr. Rayburn, you were in communication regarding lease offers to these individuals in the Wildgrass area around March 19th of 2018, correct?
That's right.
And so based off of your communications, it was asked of you if you wanted to move forward with new packets for Wildgrass at $1,500 per house. Is that right?
Yes.
And then the question was asked, do we want to move up on the royalty? See that?
Yes.
And what did you decide?
We decided to keep it at 17%.
Okay. But then a little bit below that, just a couple of weeks earlier, or 1 week earlier, same question was asked of you. We're going to do a second round of mailings for our final offer on Wildgrass. Be a flat bonus around $1,500 per house. See that?
What date of the email?
And that date is March 15, 2008.
Yes, I see. Sorry. Yes, I see the email.
So in one email, well, it's not even a couple of weeks. It's just like a few days later. So in one email, you're willing to offer $1,500 plus a bonus. And a few days earlier, it was just a $1,500 rate, right?
No.
No? Well,
No.
then can you explain the difference between the communications on the royalty?
The email from March 15th doesn't mention a royalty.
Did you offer a royalty?
Yes, we did.
What was the royalty?
Let's see, March 16th. It would have been, the broker would have taken my direction. If you review the lease offer schedule, for Section 18, the May 7th mail out had a 20% royalty that was offered.
How do you come up with these numbers, Mr. Rayburn?
These are, again, determined by our engineering group, and we get guidance for royalty and bonus from them.
I guess I didn't answer my question. How was it determined?
You mean the formula?
Yes.
I would consider that proprietary because that would be unique to each company.
Wait a minute. So you say that an engineering group uses some formula to come up with a amount and a bonus amount that then is moved over to you, and then that's what's offered to the residents. But the residents have no idea how this formulary takes place?
I'm going to object to, it calls for speculation as to what owners have ideas of and what they don't have ideas of. And Mr. Rayburn answered the question that he doesn't have personal knowledge of how the numbers are, formulas are derived.
Well, I don't think he did answer that he doesn't have personal knowledge. Let's ask the question. Are you involved in that, in how the calculation of these bonuses and what the offer is?
No, I don't have a role in determining. I do present feedback to the engineers, and if we need to adjust our offerings based on that, then that's the input that I give.
So these are engineers that you're talking about. We're not talking about finance people. Is that right?
Finance people, and what is that?
I don't know.
People.
We're talking about numbers. We're talking about offering dollars and cents to to individuals? You just said engineers. What kind of engineers are they?
These are petroleum engineers, and I don't want to speak too much to a petroleum engineer's role since I'm not, but a lot of their responsibility revolves around economics, which does have a financial component.
You know, if any company accountants or any other individuals that have experience in company finances are at the table developing the formulas?
I'm not sure I understand exactly who you're asking is involved in determining royalty and bonus.
No, I think the question was pretty clear. Is it finance people of the company who are involved in coming up with these formulas?
Again, finance people is a pretty broad term that I can't speak to under the context you're presenting.
Okay, so what we do know from you is that's petroleum engineers. Do you know of anybody else outside of petroleum engineers who are involved in developing a formula to make offers to individuals to lease their property rights?
Not to my knowledge.
And so then once you get these formulas from these petroleum engineers, then are you at will to negotiate beyond what was given to you?
We're given parameters, and so I'm able to negotiate within those parameters.
What are your parameters?
Parameters for what specifically?
It gives you some guidance as to how much you can accept or how much you can offer, like the terms, all that.
The group, so the group will give essentially a top for royalty and bonus, and so we don't start off necessarily right at that because it's a negotiation. So I've got to give some room for that when we're talking with mineral owners in this regard. If we get to a point that we need to adjust, and then I'll go back to the engineering group and we'll reevaluate and decide how to move forward.
Do you take a look at other offers that people have been made in the geographic area?
We do hear about offers, but whether those offers actually translate into leases are two different things. There could be someone making offers but never follow through on those offers.
So to be clear, when you're negotiating with Wildgrass or the Broadlands or anywhere within a 25-mile radius of the project, do you take a look at how much extraction offered those individuals?
I'm going to object to the question that we're getting pretty far afield here with respect to what is relevant under the rule. What's relevant are the lease terms and offers that are being made in the filling and spacing unit, not outside. Object on relevancy.
I would like an explanation. If you could get to the point here, it would be pretty helpful.
Sure, because the commission rule talk about geographic scope. And so what we asked for in terms of geographic scope and discovery was within a 25-mile radius of what was being offered. And so that's what I'm asking, is find out what your offers have been within this geographic scope.
Well, we'll let it go on.
Sir?
A 25-mile radius is pretty large. We did not look at a 25-mile radius of lease offerings to determine what we would offer for folks in this unit. We did not go that broad.
Okay, how about 10 miles?
We did not go 10 miles to my knowledge either.
5 miles?
Again, I am not responsible for determining the lease bonuses and royalties. And so whether or not that examination by the engineering group it went as far as 5 miles from this unit, I can't say.
Now, with respect to unresponsive parties, how did you attempt to find them?
We utilized the county records, Broomfield County records, to determine ownership and also last known address. That's filed against the property of record. And so that's how we were able to determine the individuals that were noticed within the spacing unit. Additionally, for the Wildgrass neighborhood specifically, their council provided us with names and addresses for individuals that were to be noticed in that neighborhood for leasing, spacing, and pooling.
Did you, at this point, have all individuals been noticed?
At what point?
Today, or at this point, are all individuals noticed?
To my knowledge, yes. Again, we utilize the county records, like I mentioned, and also lists provided to us to the Wildgrass Council. I've not received any indication that an individual has not received notice.
Sir, how do you know all unresponsive owners received your offer?
Each one of our lease offers are sent via certified mail, so they're trackable to ensure that we know that they've been delivered, and also to determine when the expiration or the clock for the expiration of the offer would begin, which is when the mineral owner would receive it.
So as of October 11, 2018, Vincent Kenson, he submitted an affidavit saying that they still haven't received a hearing notice or other communications. Have you cured that yet?
I'm not sure I'm familiar with this document. I've not seen it before.
Perhaps you could help us discover where that might be located.
These were part of the record for this matter. They were submitted to the COGCC earlier in the process.
Yeah, does that mean we have this in our?
They should be somewhere in. I'm sorry, I don't know how the commission keeps the records of all of its proceedings and all the documents that have been submitted to it.
Does it look like the last page of a very lengthy document?
This was a document that actually was submitted to COGCC. Extraction actually objected, saying that because these people did not notarize their documents, they should be excluded. I don't know where else to tell you. It would be in the record. We're happy to resubmit them if you can't find them. We have not produced all of the affidavits from our clients. We just have a small sample of a few of them because there were so many of them.
Is this an exhibit that was submitted?
No, this Wildgrass in its exhibits reserved the right to call up any documents that have been submitted prior in the proceedings. So this had been submitted prior in the proceedings.
Extraction objects to this exhibit. We've never seen this document, and allegations from counsel that Extraction has objected to it. We have no evidence that that's true either. So we would ask that this be struck from the record.
Let me ask the hearing officer, Mr. Eaton, have you seen this before?
It doesn't look like this is part of the final admitted exhibits. I'm looking at the final pre-hearing order now. It says that the parties reserve the right at hearing to present additional exhibits that remain in dispute. To my knowledge, no exhibits remain in dispute. I've resolved all objections, so I'm not sure where this comes from.
So I think if there were exhibits that you had seen and disputed, think it would be reasonable to present those, but I'm struggling with this one. If you've never seen it before, I don't think that falls within the final pre-hearing order, but perhaps let me ask Mr. Davenport. Here, go ahead.
I can't say for certain that I've never seen this before, that it hasn't been submitted in this case based on the amount of documents that have been submitted in this case. But what I can say that it doesn't appear that this document that they're looking at now is part of their final exhibits that they submitted. And to my knowledge, they were not proposing to submit any additional exhibits that were not included in their final exhibit PDF.
It does appear that Wildgrass's reservation of the right to call up documents that had been introduced earlier in the proceedings did not make it into the final order. So we do not have to introduce this. We can move on, and we will simply have one of our witnesses testify about this in the future.
Very well. Thank you.
Okay, thank you. Now, sir, you said that the first lease offers were to gauge the market. Does that mean that when you're trying to gauge the market that you're not supposed to provide the statutory requirements of the time periods and the notices?
I guess, are you asking if we're supposed to put a date that is similar to the statutory requirement?
Yes.
I believe the rule states that in order to move forward with the pooling, as Mr. Prashala brought out earlier, you would have to show that you've made an effort or that when you made the effort to lease those folks and presented your well proposal and AFEs, that the due date for that would need to be at least 35 days at that time period in 2018. Of course, now it's 60 days, but we were not looking to pool those individuals at that time.
So let me get this straight. If you're not looking to pool individuals, you don't have to provide them the statutory language. Is that what you're saying?
When we get to the point of pooling, because not all oil and gas wells that are drilled require pooling, when we get to the point that you determine that you will need to move forward with statutory pooling, then you bring the rules into focus, and you would put your due dates in accordance with those rules.
Did anyone respond these not considered an offer letters, these get a feel for the market letters? Did anyone respond to those by leasing their minerals?
Can you repeat it, please?
Sure. These letters that you just talked about, the get a feel for the market letters that we just discussed, did anyone respond to those letters by leasing their minerals?
Yes, we did obtain leases during each time period, I believe, with the exception, most likely probably not in July, since the second offer was so close to the July offering, the August offering, excuse me.
Okay, I have no further questions.
You finished?
Yes, I said no, I have no further questions.
Oh, sorry. Let's ask for rebuttal and then commissioner questions, and then we'll take a break.
Mr. Rayburn, you were asking some questions about Exhibit 3B. There were some highlighted areas. Were those leases, in Wildgrass or elsewhere?
Those appear to be from Section 19, which is the Broadlands.
In reviewing the lease offers that you had sent out, and the ones upon which you were looking to pool here today, I believe that those are commensurate with the prevailing market rates within this unit. The lease offers that you sent on August 27th, 2018, do you believe that those are commensurate with the prevailing market rates in the unit?
Yes.
I think you clarified this, but there's times that you send out lease offers with no intention to actually pool. Is that correct?
That's correct.
I don't have any further questions.
Thank you. Commissioners, any questions? Mr. Boygan.
I have a couple of questions. Thank you. I just want to pick up on the answer you just gave to Mr. Pashala on Exhibit 3B. Do I understand correctly that these leases that are described on the last 3 pages are not Wildgrass leases, they're Broadlands leases?
So there's a mixture, and the easy distinction between Wildgrass and the Broadlands is the section number. Section 19 is the Broadlands, section 18 is Wildgrass.
So what do the highlighted leases reflect? Why are they highlighted?
I believe the protestants highlighted those. I don't know.
Okay. Well, then you don't have to answer. My real question is, there's a fairly broad rate variation on a per acre basis. If you look at the second column, the dollar per acre, some lessors got $4,500 an acre, whether that was a flat fee or proportionate to their ownership. But most of the others got either $1,000 or $1,500, and sometimes the $1,500 was a flat fee. So I'm wondering, why was there this broad variation between $1,000 and $1,500? And the second part of that is, does it reflect whether it's Broadlands or Wildgrass?
So the difference in the bonuses paid correspond to the lease offer schedule that we presented. And so that's why you'll see some are at 500, some are at 1,000, some are at 1,500.
But some were at 4,500.
4,500 was the offering on a per net mineral acre basis. So anyone that owned more than a third of an acre was offered the $4,500 an acre.
I'm not sure that's true. When I look at this, if I scroll down just above the highlighted part, there's a lease in Broadlands. Rhonda Wade, it looks like, has 0.1273 acres and got 4,500 flat fee, if I'm reading that right.
My assumption is that would have to be a typo. We did not offer anyone a flat fee of $4,500.
Okay, I'm just trying to understand why this wide variation. Why is there a $4,500 per acre for some, a handful it looks like, whereas most were in the 1,000 to 1,500 range on a per acre basis?
The other occurrence of $4,500 is the first line. And those net acres are more than 1/3. And so that's why the $4,500 was applied to that. Or yes, because it's more than 1/3 of an acre.
Well, we can go down through the list if you want, because I see several others here that don't fit that description. So I'm just not sure that there's consistency, but so is it your testimony that your understanding is that if somebody had more than 1/3 of an acre, they got offered $4,500?
$4,500 per net mineral acre. And just quickly scanning the schedule here, the other occurrences of $4,500 an acre translate to tracts that are more than 1/3 of an acre. And so that's why the $4,500 is applied there.
Yeah. Okay. I'm not sure that the exhibit supports the statement that you just made, but I understand that's what you're saying. So the other question I have then is, if I heard you correctly, you've leased about 87% of the unit?
Not extraction exclusively, 87% of the unit is leased.
Is leased,
Right.
okay. So you're seeking to pool approximately 13%
That's correct.
of the owners, and that would be those who didn't respond, or those who affirmatively, or those who rejected your offers, basically.
Yes, those who do not respond.
Okay, so the matter before us today is concerning the pooling of approximately 13% of the mineral interest owners in this unit, correct?
Yes.
Okay, thanks.
Thank you. Any other commissioner questions? Yes, Commissioner Hager.
So on the, I'll call it pre-offer letter, the one that tested the market, I believe you testified that some people signed those when they got them. How do you make sure after they sign those offers that they get the information that is required on a lease offer? The correct time and all the notifications, things like that. You go back and give them a second notice?
The initial lease offering outlines the amount of acreage that they own, excuse me, and how that corresponds to the royalty and the bonus that we're offering. If they sign a lease based on that letter, then the next notice that they receive would be notice of the statutory pooling hearing. And that's because each owner, regardless of whether they're leased or not, receives a notice of this hearing. Now, whether or not we will, let me back up, we do not send them a well proposal because they're leased at that point. So they don't have the same, they would not need the 35 days or the 60 days to respond because they've already leased their interest.
Okay, thanks.
Couple of quick questions. One, and again, just for some clarification on this particular table, we did notice that slightly above the one you suggested was a typo. This is a Broadlands filing. Let's see if I can go across here. Pick this up. Jody J. Graham and Carolyn Graham offered $4,500 an acre for 0.07 acres. So that mostly doesn't fit what you stated.
So if you look at the column next to it, this lease may have been taken prior to January of 2018. Or actually, I guess it wouldn't.
Yeah, unfortunately, we don't have a date. Okay. Got one more.
Without having the actual lease file in front of me, I can't verify that this is what was actually paid, fortunately.
Yeah, I understand. Just one point of clarification. There was some mention earlier that they brought up some numbers in that last column, which in some respects were rather low in terms of the total dollar amount, but did reflect what's your opinion as far as the dollar per acre offer at that time? Sorry, I had to be so vague. So for example, there were some things mentioned about some low numbers about someone getting a check for $27 or $15 or whatever, but that was based on dollar per acre offer times the net mineral acres.
Right, and my inclination is that those were before we began the minimum bonus that we offered beginning in January of 2018.
Very well, thank you. Commissioner Jolly.
Did you say that everything we're looking at on this page is a 20% royalty? Because I don't see royalty on here. We're just talking about bonus at the moment.
I can't state that emphatically that each one of these leases does have a 20% royalty, but based on the bonuses that were paid, it's likely that there's a variance between the offerings of 15 to 20%.
That would probably be a rationale why there is a wide swing here, wouldn't it?
My only indication that there would be a different royalty associated with these, since we have not provided that here, is based on the minimum bonus that was paid will correspond to the time that we offered that minimum bonus and what that royalty translated to at that time.
Was there kind of a royalty of the month? I mean, when you get later, did it go up or?
So as our table demonstrated, we did increase the royalty over the 8-month period.
Yeah. I think this is pretty incomplete without knowing what the royalty is. This particular exhibit.
And the dates. It'd be nice to have had that too.
The absence of that information here is likely because the request from the protestants was just a lease schedule to course with with the reception number so they could research the leases, but not intentionally left off here.
Very well. Any other questions, commissioners? Let's take a 10-minute break.
We would just like to make a brief objection. We did request the leases, which would have been very helpful to have, and so we object to not receiving copies of those.
So noted. We'll meet again at 10 o'clock by this clock, 11 o'clock real time.
Let me write it down. I don't have a card on me.
Spend every day on that. Yeah, I was going to say, how did you not crawling there?
Thank you for
All right. Yeah.
seats. We'll start up again as soon as our hearings manager returns. Something you wanted to say?
Thank you, Chairman. We would just like to address that the document, the affidavit that was moved, that we had seen before, it alleges in it that no notice, offer, anything was ever sent to that individual. And Mr. Rayburn has looked into that and has a statement with respect to that.
Okay, before he makes that statement, we'd like to have the hearings manager come back, please. Sorry, Mr. Pachala. I was confused. Is this about the document that was not admitted?
Correct.
Okay.
Our concern is that this document is unfairly prejudiced extraction. The person that submitted is not called as a witness, identified as a witness. Therefore, we don't even know how it would be entered into the record in Wild-Grass's case in chief. But we feel it's prejudicial. We want to at least provide some clarity with respect to that individual and notices the offers that were sent to them.
Moment. Yeah. Commissioner Overturf.
It seems to me that the document that was put up on the screen has not been introduced into the record. And so to allow extraction to rebut something that was not allowed into evidence would be inappropriate. Now, if Wildgrass puts on additional evidence during their case in chief, extraction will of course have an opportunity to respond to that in rebuttal.
Very well. There's always good reasons to have attorneys here to help us out as poor engineers. Very well. So that's where we go. Ms. Larson, may I have a time check, please?
Yes. So extraction has 46 minutes and 6 seconds, and Wild-Grass has 46 minutes and 36 seconds.
So, and just to remind both parties that in the pre-hearing order that cross-examination does count against your time. To be aware of that as we proceed. Commissioner Overturf, did you have a question?
I did, thank you, Mr. Rayburn, before you leave. I did just have one question. I want to make sure that I understand the scope of the direct case that you all have put on, and that I understand all the evidence that you've presented for us to consider. And so, as you know, there's the requirement in the statute that reasonable offer to lease be assessed in the context of those offers that are currently prevailing in the area at the time. That's the language from the statute. And so is this exhibit that we've been all scrolling through here, is that intended to address that? Is this the evidence that you have about the reasonableness of the offers to lease?
The reasonable list that we presented is in the packet that you have as extractions exhibit number 1.
Commissioner Overturf, the lease offer schedule exhibit that Mr. Rayburn was testifying to that provided kind of the summary of the royalty rates, the times of the offers, was background, but the offers on which extraction is seeking to pool this unit are the August 27, 2018 offers, which are contained in Exhibit 1, extraction materials.
Okay, thank you.
Very well. Would you like to proceed?
Yes, we'll call Chandler Newhall, and give us a moment to not count against our time to get our presentation back up. Extraction's next witness is Mr. Chandler Newhall, Senior Project Manager for Extraction. Mr. Newhall, would you please introduce yourself to the commission?
Yes, my name is Chandler Newhall.
And what is it that you do for extraction?
I am the Senior Project Manager for Extraction.
And what is your experience in oil and gas?
I've been working in the Wattenberg for over 17 years now. And I've worked on things, everything from completions and operations, project designs throughout those years.
And Mr. Newhall, before we jump into your presentation, there were some questions that were posed to Mr. Rayburn regarding how petroleum engineers, the technical applying on lease offer terms with respect to bonus and royalty rates. Can you expand upon that and explain to the commission how the engineering group is involved with that?
Yes. So when we look at a particular project, we'll look at a number of different factors that go into determining the project economics, everything from, the capital costs of, drilling, completing those wells, bringing those wells on production. We'll take a look at, the well performance, and that's based upon, historical data around there and geology. And we'll look at, also what our working interest is and what our overrides would be, and we'll determine a range from that, present that to management, then that is approved. And so it's kind of a brief overview of how those are.
So can you explain the relationship between perhaps maybe the quality of the rock and a royalty rate that might be offered? Is there a difference if you're in the core of the Wattenberg, are the rates that are offered higher or lower than a fringe area?
They'll tend to be higher.
If you would like to start with your first, the first slide, Mr. Newhall.
Okay. So as many of you may know, this development project has been very robust and an actively engaged process over the past 3 years. The design components of this project has been very open and very transparent with focus on protection of health and safety in the environment. During this time, we had collaborated with Broomfield, City Council, members of the community, and we actively participated with the Broomfield Task Force throughout 2017. All of this collaboration culminated with an operator's agreement in October of 2017. During this time period, while the task force was researching, Extraction took that opportunity to take a pause on the permitting process and participated with the task force until the recommendations were incorporated with the best management practices into the final operator agreement with Broomfield. The comprehensive plan, drilling plan submitted to Broomfield in 2017 and approved in 2018 outlines how the BMPs would be implemented. Additionally, throughout this period, the COGC was also actively involved. They participated in the first bank forum in February of 2017. They also provided presentations and answers that Broomfield Task Force had. The COGC also hosted a special hearing in Broomfield back in October of 2017. This concluded with the approval of the spacing unit in October of 2017 and approval of our Form 2As and 2s in July.
Mr. Newhall, do you know if members of the Wildgrass Oil and Gas Committee or the Wildgrass residents were involved in this process with Broomfield?
Yes, I believe they were.
The next slide is like a description of the Lowell South unit and location. Can you please describe this for the commission?
Absolutely. So throughout this process, Extraction was committed to listening to the final recommendations that the task force provided. As a result, the Livingston pad location was approved by Broomfield, which accommodated the task force siting recommendations. What you see here is the final location of the Livingston pad, and it accomplished multiple benefits. One of it was it eliminated 4 other original approved sites, and those can be identified here as the red sites. So those were originally approved MOU locations. It also eliminated the Sheridan pad. So that one's identified in gray up to the point 2 here. Up here to the north and east. That was the original Sheridan site. And also as a result, the task force had made recommendations, and that resulted in the Livingston pad ultimately moving subtly to the south and west. Finally, the Livingston pad established with the operator's agreement 57 BMPs that were designed to protect health, safety, and the environment.
And just for clarification, those 57 BMPs, were those crafted with the input of the task force?
Yes, they were. And on the task force, what I'd like to touch on there is, what they were able to accomplish during this time period. The task force was a 14-member citizen team, which was selected by Broomfield Council, and they were focused on oil and gas recommendations for updates to the regulations within Broomfield. There was multiple contributing industries, universities, parties that participated. There was a lot of information that was provided on oil and gas operations for the task force to take a look at. The task force had broke off into 4 different branches or subcommittees, and they did further investigations on impacts related to community, to health, to legal, and to planning. During this time period, Extraction voluntarily participated by attending the meetings. We supplied data on all of our operations that were ongoing in the field. We provided field tours on drilling, completion, and production operations. Additionally, we allowed for the task force to take sampling at our active sites to monitor for noise and air impacts. And this data was further validated by modeling that was done for oil and gas operations.
And Mr. Newhall, do you know whether or not some of these studies or the samplings, the water baseline studies, were those produced as exhibits in this matter?
Yes. On this slide here, one of the multiple items that makes this project so unique and innovative is the focus of BMPs protecting each of the environmental elements related to air, water, soil, and noise. Systems are planned are being implemented for the protection of each of these different components. We've conducted new baseline monitoring at the Livingston site. We've installed over 60% of the pipelines for oil, gas, and water to support low VOC systems. Soil testing is underway and plans to remove legacy wells throughout the Broomfield project. Removal of these legacy wells directly relates to the elimination of truck traffic in neighborhoods, production separators, tanks, and flow lines, while restoring and returning the land back to these different neighborhoods. We have contracts in place right now for new sound wall technology. We also have installed electrical systems which support our electric drilling rigs as well as our facilities. And in 2018, 40 acres were restored and conveyed to Broomfield as open space as part of this project. Extraction, we have demonstrated and are committed to making our Broomfield project best in class.
You used the term VOCs. Can you explain that term for the commissioners?
Volatile organic compounds, and so a lot of those are controlled within our drilling system and closed loop systems that we've got planned, within our completions, and within our facilities, as this is tankless, permanent tankless location.
I think that's a good segue into your next slide regarding the air quality.
Right. So this chart illustrates a baseline sampling that was conducted by the task force at possible locations within Broomfield. Just kind of point to some of these here. So on those original sites, here this was sampling that was done at Lowell and then at Sheridan. And during this time period, the Livingston site was called the Lowell pad, and we also had the Sheridan pad. And so baseline sampling was conducted there. Those results were then compared to actual samples collected at our fracking and flowback locations. So this is where they went out, they set monitors, and they collected those samples from our active locations. And so you can see that in these different charts here. We also provided what field equipment we'd be using, and that was modeled for each of those various operations, drilling, fracking, and flowback. And all this modeled and actual field samples were far below what the published risk limits are. And those are displayed over here on the right. It is our commitment to air quality and can be demonstrated through the implementation of these best management practices by using electric drilling rigs, by using dual fuel systems on frac equipment and by our electric facilities.
Mr. Newhall, is this the first time that this information has ever been provided to Broomfield or the public?
No.
Just roughly, how many times have you provided this information as part of the operator agreement negotiations and comprehensive development plan discussions?
It's been provided at several different public forums, the task force, and we've been participating with that.
Now, this next slide.
Yeah, what I wanted to show here was we're very proud to show what we were able to achieve with the implementation of these BMPs. By implementing all of these BMPs, we're anticipating that no CDPHE air permit will likely be required at the Broomfield well sites. This chart compares VOC emissions for other various industries. For example, when we were working with the task force, we took a look at what is the most wells we think we could see on a Broomfield location. At that time, it was 42. And even with a 42 well pad, we were anticipating to have fewer VOC emissions per year than even a Broomfield gas station. So, but as a result of the operators agreement, the Livingston pad landed at 19 wells, the max which is allowable by the Broomfield operator.
What is this next slide? I think we presented this before back in August, actually, but it makes sense to re-present it here.
Yes, yeah, we did present this back in August as well as in October too. This slide summarized the BMPs that are being implemented that were recommended by the task force at the October 12th hearing that was done in Broomfield. These proposed rule changes were incorporated into the operators agreement with Broomfield, including the permits with the state. Among them addressing noise limits, use of electric drilling rigs, requirements for closed loop systems, use of pipelines for produced products. The agreed pad sites meet the setback distance recommendations for residents of both the Broomfield. We had agreed to baseline, and we continue to do baseline, we've agreed to baseline and ongoing water quality testing. And we also had agreed to insurance requirements that were 100 times that were set by the state. There was also other multiple provisions within our operators agreement that we agreed to with Broomfield. This just really summarizes most of the best management practices.
As part of the operator agreement, did it require extraction to submit all 57 BMPs on its Form 2A application?
Yes, we did.
Did extraction do that?
We did, yes.
And as part of this process, was there any collaboration with first responders?
Yes, we've had quite a bit of engagement with first responders. And I could show that here on this particular slide. And so this just outlines a number of BMPs that we've already done so far to date. In May of 2018, we started the installation of the pipeline gathering system, and we've completed over 60% of that. This pipeline system is instrumental in supporting our VOC systems that support air quality. We've installed electrical infrastructure for the drilling rigs and facilities. We've updated baseline monitoring. It's been conducted at the Livingston pad, and this has also been published. We have entered into a number of contracts supporting many of our other BMPs. We have engaged with Bloomfield on training exercise along with weekly and monthly meetings detailing our progress and continued collaboration on project improvements. We are very committed to perform all the BMPs detailed on the Form 2A, as well as all the BMPs outlined in our Bloomfield Operators Agreement. We are striving to make this our best-in-class project.
And what does this last slide represent?
This last slide here shows the index from our comprehensive drilling plan that was submitted and approved to Broomfield that outlines how all of the different BMPs are going to be implemented in this project. I guess just in final, this project has been a very engaged process. We've had significant collaboration from all different parties, from the task force, from Broomfield. It really allows us to develop in a manner that optimizes resource extraction while minimizing waste. It protects correlative rights while protecting health, safety, and the environment. And I believe what we've done so far today really demonstrates our willingness to continue to do all these BMPs.
Mr. Newhall, in 3 years of experience working with Wattenberg Field, have you seen, been involved with the project with this level of best management practices involved?
Not with them all instituted into one place. Usually it's a fit for purpose on your different BMPs throughout the basin. And this is an opportunity within our basin where we can look at the toolbox and we can apply all of the tools that we have in this particular setting.
Thank you.
Ready for cross? Mr. Salazar? Or, okay. Yep.
You'll give us just 1 second to pull our exhibits back up. There seems to be a technical difficulty. Hold on.
It's all right, Ms. Merlin, take your time. We won't count this against you.
Oh, no. In the interest of just saving everyone some time, that exhibit's not terribly crucial. I will say that the exhibit I was trying to pull up is listed in your folders at Exhibit P, Wildgrass Exhibit P. It is a study of health and safety impacts and setback adequacy that was disclosed to Wildgrass by extraction. That's what it would have been. P is in Peter.
And what page?
Page 870.
870. Thank
Thank
you,
you.
Commissioner Overturn.
So just a few questions for this witness. Did Wildgrass get, you mentioned the spacing unit protest, which Wildgrass filed, and that the issue was eventually resolved, you said in October of 2017. Did Wildgrass get any discovery on health and safety in that matter?
Jack, this is not any part of the direct testimony, and Mr. Newhall is a fact witness. This is a procedural question that really should be directed at counsel.
So, I will clarify that Mr. Newhall did bring up this spacing unit protest, claiming that because spacing unit dealt with health and safety and Wildgrass participated in that, that somehow that issue was satisfactorily addressed with some conclusive effect regarding the health and safety of this project.
Objection. That was the witness's testimony whatsoever.
I don't recall that. Could you go back and reference where that was, maybe perhaps what slide he was speaking to when he brought that up or something?
Yes, he was speaking about the approval of the spacing unit in October of 2017, and that Wildgrass was involved, and that health and safety was addressed in that hearing. I don't have the slide number, I'm sorry.
Is this perhaps the timeline?
See if I can go backward.
Might be slide 26 in the presentation, which it does talk about the air quality, water and soil quality, cultural, environmental. Perhaps that's the one that you might be referring to, Ms. Merlin?
Oh, I thought it was canceled for slide 20. Paul's introduction regarding the statement that this process concluded with approval of the spacing in 2017.
It was generally in this vicinity of the slides that he was discussing the process of the task force, the operator agreement, the spacing unit protest, and the final approvals. So
Perhaps you could rephrase the question that it would be a little bit closer to Mr. Newhall's testimony.
I mean, my question was simply whether or not Wildgrass obtained any discovery on health and safety issues in that spacing protest. If, if
perhaps
Mr. Pierce-Chawla is willing to stipulate that Wildgrass did not obtain any discovery on health and safety in that spacing protest, then we can move on.
Or perhaps Mr. Newhall, just to his knowledge, could testify as to what he recalls from that protest.
I'm not sure on what she might be referring to on the particular protest, but what I do know is, the task force looked at all different type of impacts for drilling and completions and production. They made a recommendation to Broomfield Council. They adopted those regulations. That was presented then those recommendations were presented October 12th at the COGCC hearing, at that special hearing up in Broomfield. And then we met a number of all those BMPs that were recommended related to public health and safety.
Okay, Ms. Merlin, what particular protest are you referring to?
I was speaking about Wildgrass's protest of extraction spacing unit application.
Okay, and the question was, again?
Whether Wildgrass received any discovery on health and safety issues as a result of that protest.
Okay, so I think Mr. Newhall, perhaps that's when, to the best of your knowledge, can you answer that one?
No.
And can I ask a clarifying question?
Yeah,
of
go ahead,
of Council
Commissioner
for
Overturf.
Wildgrass, because one thing that concerns me is that we've got two different entities here. So when you refer to Wildgrass, are you referring to the Wildgrass Oil and Gas Committee, or are you referring to the Wildgrass Master Association? My understanding is that it was the Wildgrass Master Association that was the protestant in the spacing matter. Is that accurate?
So in the spacing unit matter, Wildgrass Master Association was the first protestant. Wildgrass Oil and Gas Committee then later joined the protest and incorporated by reference the grounds on which Wildgrass Master had first raised the protest.
And did both the Wildgrass Master Association and the Wildgrass Oil and Gas Committee, they both withdrew the protests? Is that correct?
That is correct.
Okay, thank you.
Thanks, Commissioner Overturf.
Was there final commission ruling on health and safety at that spacing unit hearing?
I don't recall.
Do you believe that the commission order in that spacing unit application said that the permits would comport with the BMPs? Yes, in the spacing unit orders issued by the commission, did the commission order that the permits would comport with the best management practices from the operator agreement?
You know, object to the question. I think that the order speaks for itself. I don't think we need to have witness testimony as to what is in the spacing orders. If council would like to pull up the spacing orders and present it from the commission, she's free to do so. But I think this is an improper line of questioning for a witness who is here to talk about the project benefits to public health, safety, and welfare.
So Ms. Merlin, can you help me understand
Yes.
the line of questioning here? Because I think Mr. Perchala does have a point. We can read the order, how the order came out.
Of course. So I'm attempting to set up the line of questioning to get from the witness whether or not he believes that the final approved permits do or do not comport with the operator agreement, because there's been some testimony here that the best management practices of the operator agreement will provide adequate health and safety, and that because Broomfield negotiated best management practices, that this will inure to protect Wildgrass, and that Wildgrass should be satisfied with the health and safety protections.
I'm a little old, but I do recall we have a hearing on that matter this afternoon,
That
so
is correct.
let's move on.
All right. So Mr. Newhall, you testified that the Wildgrass pad was moved to the south and the west from the original proposed location?
Yes, it was.
And is that towards or away from the Wildgrass neighborhood?
Well, as the task force evaluated siting analysis, and we worked through the alternative site analysis, they came up with a different number of levels or what distances Broomfield believes that a pad should be located. And to accommodate and meet those guidelines, the Livingston pad was shifted slightly to the south and to the west. But this also eliminated a number of other already agreed upon sites, and it also eliminated the Sheridan pad location.
Did Wildgrass directly participate in the decision to move the well towards the Wildgrass community?
I don't know. I know that, the task force came up with a different rationale for how a pad might be sited, and extraction accommodated and met what the recommendation was.
How many extraction facilities have experienced fires or explosions?
Objection. There was no testimony whatsoever on direct regarding other locations and explosions.
Again, can you help me understand the line of
Yes.
questioning here?
The entirety of this witness's testimony goes to how safe an operator extraction is. That it's incredibly safe and healthy to be right in the middle of these communities. Yes, they've implied that they're safer than a bakery. And so we are asking questions about whether or not and how many of Extraction's other facilities have experienced fires or explosions. And we think that's directly relevant to the question of whether or not Extraction can be trusted to be a safe operator in and among these communities.
I think what they actually said was in reference to slide 29, that their VOC comparison was less than a bakery, not safer than a bakery.
Okay. Again, his entire testimony went towards the health and safety of Extraction, being an incredibly careful operator.
I think I'll allow the question.
Can you restate what the question is, please?
How many of Extraction's facilities have experienced fires or explosions over the past, let's say, 5 years?
I'm sorry.
Commissioner Overture, please.
Can we please stop talking to the witness in response to questions?
This is so far outside of his testimony. It's whether he can answer the questions or not. But fair enough.
I can't answer that specific question because I'm focused on the development components of this, and I've been working on this Broomfield project since 2016. And I know Extraction in 2017, we withdrew permits and took a pause so we could participate openly with the community in a transparent process to come up with what best management practices should be implemented into this project. What I can say is, there's a number of legacy wells throughout the neighborhood here that are much closer in distance to, houses or proximity to, different structures. And all those locations we're going to be removing. We're going to be removing truck traffic throughout neighborhoods, tanks, separator equipment, flow lines. So to speak to the impacts of health and safety, this project is safe in that we are removing things that are throughout the neighborhoods, and we're going to bring in new and innovative technology that's tankless, that has electric rigs.
So, I'm sorry, I'll just stop you because it's going on quite a bit, but you are a senior project manager for extraction oil and gas,
Yes,
and you don't know how many fires or explosions extraction has
I'm a
experienced?
senior project engineer with extraction.
How many notice of alleged violations does extraction have in front of this commission?
We'd have to talk to our safety department.
Objection, we're getting far afield here. I mean,
We are kind of rambling a bit. If you can help me understand the line of questioning, where we're trying to go with this line of questioning in particular.
Yes,
I think,
again.
so before you answer,
Sorry.
remember, he's the senior project engineer. He is in charge of this specific project. He may or may not have information with respect to their NOAVs that may come under their regulatory department. Welcome. I'll let the questioning continue, but just remember, he may not have full knowledge of that because it's not in his area.
I would ask that the commission take administrative notice of the notice of alleged violations that extraction has incurred. Do you know whether extraction has ever been fined or otherwise sanctioned by the COGCC for rule violations?
Related to this project? No.
Related to any of its projects?
I don't know those specifics that you're looking at. I'm not sure what she's exactly referring to. But I know we've been conducting operations in Broomfield since 2018, from installing pipelines. We've built pad locations, we've built access roads, we've conveyed over 40 acres to Broomfield as open space and cleaned that property up. We've started doing legacy plug and abandonment as per the operator agreement. Speak to that.
Okay, thank you. No more questions.
Commissioners. Oh, yes, sorry. Thank you for that reminder. Rebuttal.
I'm sorry. May I ask, I want to clarify a request that was made by council for Wildgrass before we move on to the rebuttal.
Certainly, Commissioner.
So you asked us to take administrative notice of NOAVs.
Yes.
Do you have them?
No, but I'm happy to provide them.
I mean, I think they would, my understanding is that we can't take administrative notice of general things without something to actually put into our record. So I'm not clear what to do with that request. Or perhaps it's something that we come back to at the end of the hearing, but I don't want to just leave it hanging out there and have there be an assumption that we have taken administrative notice.
Good point. Thank you.
These things.
Understand.
You'll be able to provide that by the end of the hearing.
Yes.
Very well. Commissioner Boygan.
I would just respond. I agree with Commissioner Overturf. The way I understood the request was that we should take notice of our own records. Is that what was being requested? Okay.
Yeah, but I agree.
I'll be able to provide you with document numbers or whatever you require.
I think you asked the question was the number of NOAVs that extraction has received. I don't think there was a specific time frame or anything along that line. So whatever record you want us to see, make sure that we see that.
Of course, thank you.
Mr. Perchal.
Just a couple questions from Mr. Newhall. Mr. Newhall, are you aware of whether Wildgrass's identified witness, Ann Myers, was part of the the Broomfield Task Force?
Yes, from my participation at the task force, she was a member of it.
Then there was questions from council about the Kingston pad being moved to the southwest toward Wildgrass. Did that create a further distance from residents to the north?
Yes, it did.
further questions.
Very well, commissioners, any questions? I have just two. When you move the Livingston pad, what's the minimum distance from the pad to Wildgrass at this point?
Yes, so the distance from the Wildgrass pad to
Livingston pad.
to the Wildgrass neighborhood, the closest residence like 2,200 feet.
Okay. And you may or may not know this as the project manager for this, how the number of NOAVs that Extraction has received that are within your city and county of Broomfield, for your operations within city and county of Broomfield.
None that I'm aware of, but we could certainly ask our EHS manager who is sworn in today.
Yeah, that would be, we'll save that question, or if you can remember that, please, that would be great. All right, thank you very much. What's our time looking like, Ms. Larson?
Yes, so Extraction has 30 minutes and 8 seconds, and Wildgrass is 40 minutes and 58 seconds.
Okay, Mr. Pachala.
We'd like to call our next witness. That would be Mr. Clayton Doak. Mr. Doak, would you please introduce yourself to the commissioners?
Good morning. My name is Clayton Doak. I am Senior Petroleum Engineer at Integrated Petroleum Technologies.
And would you please describe your experience and work that you've prepared for today?
Sure. I have approximately 11 years of experience in the oil and gas industry. The original and revised testimony or updated testimonies provided in this matter was done under Neil Duncan's signature. Neil Duncan is my colleague at IPT. He and I worked on it together, and I'm here in this process.
Did you prepare economics as part of the spacing hearing?
Yes.
And you prepare updated economics for us here today?
Yes, indeed.
And Mr. Doak, put a slide up. Would you please explain to the commissioners the economics that you run?
The economics of this project are efficient. They will economically develop the unit. They result in positive rates of return and will prevent waste and protect correlative rights. The internal rate of return for the average well within the 13.5 mile pool application is 65% with a payout of 2.1 years. That is based off of revised oil pricing since the spacing hearing, as well as some updates to decline curves based off of the analogous wells. Additionally, it includes enhanced operating costs of $15,000 per month, which is more than what is typical. And additionally, it includes a CapEx enhancer of $300,000 per well in order to comply with the Broomfield fee.
In your experience, what capital expenditures are borne by the working interest owners and unleased mineral owner interests?
So the drilling and completion costs are CapEx borne by working.
And what about operational costs?
Op costs are also borne.
Now, in your experience in the basin, do you have familiarity with pipelines, large pipeline gathering systems that transport oil, gas, water from well sites?
Yes.
And who typically bears the cost of constructing such pipelines?
The midstream company.
And in your opinion, regarding the cost parameters that have been used by Extraction in developing these economics, are they conservative? Are they skinny? Can you describe a little bit on that?
So the costs associated with the economics are derived from Extraction's public statements, again with the intent for localized fee increase.
In your opinion, can you please describe the economics, your view of the economics for this low south unit?
So the economics are, as previously stated, positive and result in an efficient and economical development of the unit.
Can you explain the impact on waste?
These wells do not result in waste and protect the correlative rights.
Yep. I'd just like to make an objection that the witness appears to be testifying to ultimate facts and disputing this issue.
Mr. Pachala?
The issues of waste, correlative rights, and economics are issues that were determined by this commission at the spacing hearing. We're really just visiting those based upon the protest of Wildgrass that are certainly not, well, to the extent that they're ultimate issues, an expert certainly has, is within the realm of an expert to give an opinion as to whether or not these facts satisfy the statutory mandates.
Very well, I'll continue to allow it with one momentary thing. Enrique or Ms. Larson, I had a text message that says there's a very bad echo on the audio. So if there's anything that we can do to help that out for the folks listening online, that would be great.
Thank you, Mr. Chair. By chance, when did you receive that? We did receive correspondence earlier this morning to that, and we thought we had it rectified, but
Some
if it's
time ago.
Okay,
So I just noticed it, sorry.
Okay, no
All right.
worries. I appreciate it. Thank you.
Yep. Sorry.
No further questions from Mr. Doe.
Very well. Who's going to conduct the cross?
I'll have a cross, Commissioner. Thank you.
Mr. Salazar.
Thank you very much. Mr. Docket. Now you just rattled off a bunch of numbers saying that you consider this, that, or the other. Where's your report?
I'm sorry, repeat that?
Where is your report?
It is in Exhibit 13.
No, that is your statement. Where is your report with your methodology?
The methodology is attached to Exhibit 13. It is the standard methodology used in. Sure. I'd be happy to explain it if you'd like.
Yes, please go ahead.
Sure. So there, the way we perform the evaluation is that we review offsetting production. This data is publicly available. Offsetting production. We pick an area that is nearby that we view as analogous. Then what we do is we analyze the production of the analogous wells. We provide upscaling factors to those based off of which provides us an indication of the subject wells. And then we perform the economic evaluation on the subject wells, also based on public.
Upscaling factors. What are upscaling factors?
So upscaling factors typically are derived from engineering evaluations. Tudor Pickering Holding Company does one. In this case, we actually did an enhanced upscaling factor. You will note in Exhibit 13 that we have cumulatively reconciled the total production in a way that forces the perpendicular drainage distances to be equivalent. And what this does is it provides a two-scale correction, a correction for lateral length and a correction for differences in formation height, which do exist in this case between the analogous wells and the subject wells.
Now you said that this was based off of, publicly gathered information?
All of the data contained herein is publicly available, yes, sir.
Okay. And I'm sure that you also took into consideration too publicly held information or accessible information in the SEC's 10K and extractions financial position?
That is beyond my ability to testify.
So hold on a second. So you're talking about the economics of these wells, but then you don't even consider extraction's own statements that it submitted to the SEC about risk factors?
We pull data from their public reports, which includes data they submit to the SEC and presentations they provide to their investors.
Yeah,
all of that is public.
Which would be the SEC filing, where extraction advised their shareholders that our development and exploratory drilling efforts and our well operations may not be profitable or achieve our targeted returns. Does that factor in?
This evaluation provides information that in this project's case, that general statement does not apply.
Okay, well then how about this statement? Our exploration and development projects require substantial capital expenditures. We may be unable to obtain required capital or financing on satisfactory terms, which could lead to a decline in our reserves. How about that? Does that factor in?
Object on the foundation. There's been no testimony that this witness is familiar with extractions 10K or any of the statements therein.
I'm sorry, Mr. Commissioner, you said that they were gathering information from publicly available sources and what they were presenting to stakeholders, and this is what they presented to stakeholders.
Council never clarified what that public information is with the witness. Now he's speculating that the witness has actually considered the 10K.
So, here's
a quick clarifying question.
I'm sorry?
I could ask a quick clarifying question.
Please proceed.
Did you consider the 10K?
No.
Why not?
It is unnecessary for the evaluation of this project's economics.
So when extraction is advising its numerous stakeholders on a project that might surpass $1 billion, and extraction is advising its stakeholders of numerous risk factors that go into the capitalization of this project, you're saying that that is unimportant?
Objection. This witness has been presenting technical engineering testimony limited to economics and no foundation that he has any knowledge of what extraction is representing to the public regarding risk factors.
Help me out here, Mr. Salazar. Where are you trying to go?
I'm trying to figure out what their methodology is in his particular report and saying that the economics of this project are good.
So I think, and my recollection is that what he had worked on was specifically related to evaluating the project economics.
Right.
Not necessarily the financial condition or what extraction may present to its shareholders.
Well, I don't know. He was saying all sorts of things, inclusory statements about how it was going to be, payout for 2.1 years, $15,000 a month, $300,000 a well, going into how the economics of it were good. All of these other kinds of factors, he opened the door wide open for me to ask him questions that obviously extraction's own statements contradict what he's saying.
What I heard was strictly related to this specific economics of drilling and completing these wells. And within that scope, I think he's testifying as that expert. I don't believe that, although he did punish himself by going back and getting a master's at School of Mines, I don't think he has an MBA. So I think if we could maybe stick to questions specifically related to the economics of the project,
okay,
and not the financials of extraction.
How about
for this witness?
Thank you, Commissioner. And the economics of the project here, if you take a look at what we have as exhibit. We'll identify the exhibit a little bit. So here's the economics.
Objection. I think we need to identify the exhibit before we start taking testimony.
Yeah, this looks like it came out of something else from somewhere else again, because I'm seeing 1740 out of 1755. So
yes. So that is the list of Wildgrass's exhibits. This was one of the financial documents disclosed by extraction in this matter. These are authorizations for expenditures of the Livingston wells. These show that even in the absence with zero accounted for numerous capital and operational costs, that each of these wells will cost, I think the range is somewhere between $5 and $7 some odd million. So we would like to ask some questions, given the profitability calculations, whether or not those calculations depend on omitting some of these costs. So for example, $0 for plugging and abandonment, $0 for air permitting and compliance. There's a lot of zeros in this authorization for expenditure, which discusses a quite expensive process, even in the absence of $0 for legal fees. I don't know how much it's costing them to defend the permits here today, but I'm pretty sure it's above $0. So if they're not calculating any of that in their economics of the project, I want to know if these economics of the project can be relied upon.
And notionally, even though this may not be in there, Mr. Pachala, I'm presuming it would tie to sort of the last 2 pages of Extraction Exhibit 13, which does have an economic report which lists some capital expenditures. But hold on a second.
Is this the same as Extractions Exhibit 2?
I believe so. Yeah, these are the AFEs. We're not contesting that these aren't our AFEs. I just don't think that this witness is the appropriate person to be discussing the AFEs, since he's running an economics analysis based upon decline curves, cost parameters that are given to him. And I think we have a better witness, Mr. Newhall, who can better answer the questions that they may be wanting to present regarding this.
Sure, and I'm not asking, I just want to know if it's already in the record. Do you agree
Thank
that this
you.
is the same as Extractions
Yes,
Exhibit 2?
everything's in the record.
Okay, thank you.
All right, very well. Thank you, Commissioner Overturf, for bringing that to our attention. We have a couple of options. We can finish up with this witness and bring Mr. Newhall back. Which I think might be the thing to do. So just a moment. Okay. You can ask the questions. If you want to bring Mr. Newhall back, you can do that.
Yeah, we have no further questions.
Very well. Commissioners,
Sure.
because
Oh, you want
you get a rebuttal.
Right. I have no further questions for the witness.
Thank you.
one quick question.
Mr. William?
In your economics, you're using 46.42 flat for your oil pricing.
Correct.
You know what you're netting out there today?
That is probably a question for extraction. As far
Well,
as-
all right, let me ask it a different way. Would you expect that the price you're getting today is higher than that?
Higher or similar.
So this would be a pretty conservative price,
That's relative.
and it's flat, it's unescalated.
Right, it's flat, right.
Okay.
And just to clarify, this is your net wellhead price?
No, that's-
Okay.
Thanks, that's all I've got.
Any other commissioners? Commissioner Egger?
I just have one question. You made a comment when you were showing the economics that the operating costs per month were more than typical. I think it was 15,000.
Correct.
Can you explain why and how much more than typical?
That was added as sort of a way to account for perhaps some unanticipated costs that would result from complying with room for abuse. Typically, we see op costs around $8,000 to $10,000. That's usually what we use for evaluation. 15 plus.
Okay, thank you.
Any other commissioners? 2 quick questions. Your gas price is $2.49 per MCF. What's the BTU content of the gas out here?
It is about 1,200, as I recall.
Okay. And what did you use for shrink?
Do not recall.
Okay. Thank you very much.
I'm sorry, may I ask just one
Yeah,
question?
certainly, Commissioner Overturf, sorry.
So this is I'm going to try, okay? So I have recently read some articles about a decrease in the expected output of both gas and liquids in shale formations due to interactions between parent and child wells, that there's less output than one would expect having at the front end. I'm wondering if you have, if you see that as an issue in this circumstance, and or how you have addressed that potential in your analysis here.
Sure. I do not see that as an issue in this case. I believe they intend to develop the entire thing all at once. There is evidence, as you say, that when we do full development in one single shot, that is a more efficient, an incrementally more efficient way to develop, but it's not.
And I imply in your response then that there are no existing wells in this area that you accounted for?
Right.
Okay, thank you.
No more questions? Thank you very much.
Thank you.
Unless you want to hear from Mr. Newhall regarding this exhibit, we have no further testimony.
Just a moment. Okay. So I guess it's a question for us as commissioners. Do we want to hear from Mr. Newhall again? Yes?
Yes, regarding no question.
Very well. Would you please bring?
It would be my understanding that the questions would be from the commissioners, not from council for Wildgrass.
Yes.
I'm sorry. We were deprived of an opportunity to question the last witness about these because we were told that that was not the correct witness. And now we can't question this witness because only the commission can question this witness. I'm very confused. We just wanted to ask the question. All right, the commission can go ahead and ask the question. Thank you.
We'll start with Commissioner Ager. Perhaps we may ask the question that you're looking for.
Thank you.
Okay, I think we just wanted some further explanation on the AFEs on some of these values that were entered as zeros and why.
So these, some of the zeros that you see on here, like for example, if they pointed to the plug and abandon, that's not included on this because when we go to plug and abandon a legacy well, then there's an AFE generated for that specific well that doesn't reflect for the drilling and completion of this new well. So that is not included on the individual AFE that's sent.
Those costs are borne somewhere else,
Correct.
not to any of the mineral interest owners here. Air permitting, I'm assuming because of the emissions modeling you presented?
Yes, that's correct. These are basically what you'll have as a standard type template where costs are generated based upon the type of projects that's being done. And so there's a number of different allocation places where you could put items to for AFE codes. And so if those items aren't on this, then that code is, wasn't identified in this particular one. So a zero doesn't necessarily mean that, it doesn't apply to this project.
If it's on this AFE as a task, let's call it, or a line item, if you incur it, it will ultimately contribute to the cost of the well. This is just projection.
That's right. This is a projection. This is a conservative figure that's put together that is used at the time when the AFE is generated.
And to your knowledge, this was put together and prepared based on site-specific or well-specific parameters. It's very local to these wells.
Yes.
Thanks.
Commissioner Overturf?
So where I understand what you're saying, that plugging and abandoning you're not including in this AFE because it's included in a different AFE. Nonetheless, do you assume those plugging and abandonment costs when you kind of roll up and do that overall project economic assessment?
Yeah, internally for the full project economics, we do.
And so what are the plugging and abandonment costs per well that you're assuming when you conduct that analysis?
That's a variable cost, but typically can average $50,000 to $100,000.
Okay.
And is the air permitting and compliance similarly treated where it's listed as a 0 here, but it is nonetheless included in the overall project costs?
That's correct.
And so what do you expect as the compliance costs? Do you have a general estimate of those costs that you use for that other purpose?
So a lot of those compliance costs are within the facilities themselves. So within the Broomfield Operators Agreement, it's $20,000 per year on an annual basis for the whole project. And so that's separate from this. So to be compliant with the different air components of this is to use the electric drilling rig. So the electric drilling rig's identified in here, the closed loop system, the facilities, the pipe. So those things are included on the facilities.
Right, I understand that the best management practices are, but even if you do all the best management practice stuff that you're required to do under the Broomfield Operator Agreement, you're still required under state Air Quality Control Commission regulations to conduct regular inspections and that sort of thing. So that seems like a separate category of costs, or are you saying that those costs are rolled up into the?
That's a separate category, that cost.
Okay, and what's your annual estimate? Do you have an annual estimate for those Air Quality Control Commission regulation compliance costs?
Not off the top of my head.
Okay.
Mr. Boygan.
Thank you, Mr. Chair. A couple of further questions on the AFEs to follow up with Commissioner Overturf's questions. Are the kinds of compliance costs that she's referring to typically billed to a well, to a working interest owner in a well, or how do you account for them?
Some of those will be also accounted for in the LOE component. So where we had the $15,000 per well for the LOE per month, a lot of those are.
And LOE for the uninitiated?
It is the lease operating cost.
And does the AFE actually have an LOE component to it?
No.
In other words, the AFE just covers drilling and completion costs, correct?
That's correct.
Not ongoing costs of operating or compliance, correct?
That is correct.
Similarly, for your leasehold costs on the AFE, you show 0. And I'm assuming that's because, well, I'll ask you, is that because none of those costs are billed to the working interest owners?
That's right.
And then finally, I notice you have a contingency of 5%. Is that your typical, well, let me ask it a different way. What's that intended to account for?
Price increases from different contractors or things like that.
So was it intended to account for the kinds of risk factors that Council for Wildgrass was alluding to, or just operational type risks?
More operational type risks.
Okay, thanks.
But I'm waiting to see if Commissioner Jelly has. Oh, you're good. All right. So just a couple of quick follow-up questions. Would you characterize that 5% contingency as sort of an industry standard number?
Yes, I would.
So other operators would do the same thing. And I think I heard, just to make sure, that anything that's sort of listed down here on the leasehold, which would include seismic, geological, sort of a dog's breakfast of information down there, all of that would be costs that extraction would bear in its entirety to put this together, and would not be charged to any of the working interest owners or participants in this particular pooling.
Yeah, because we didn't run seismic on any of this.
Okay, so sorry, everything else, you've got brokerage fees, land commissions, permitting, bonus payments, legal. And so some of the things that came up, all of those costs, extraction pays for that 100%. It won't get charged to the working interest owners?
No, so there's also a pre-drill that is done on these different projects. And then once those get closed out, they can get rolled back into the different specific AFEs. So there could be some slight dollars associated with that there.
Okay. And where does that get accounted for in the overall project economics then? Because when you look at this, we were presented with economics, said, here's what it costs to drill and complete the well. And you said plug and abandonment costs and some of the other upfront costs were included in that, and may not necessarily show up here in this AFE, but you made sure that Mr. Doak had that information when he did his economics. So was there a material amount of costs that didn't get into his project, in his well economics, that would be in the project economics?
So what we'll do is we'll take a look at historical costs that we've had, because we drill a lot of horizontal wells throughout the basement. So we'll look at those costs, actual costs that we've had on wells. And then we'll come up with a projection of what we think the next well, set of wells coming, what those costs are. And then we'll look at what BMPs will be include those on that project economic, determine what economics look like. So we'll basically take a look at the historic figures.
Sort of a roundabout way that I heard, and make sure that anything that you've incurred for costs previously, you're going to make sure that that's included in your well economics for the next set of projects.
Correct.
Even though if they don't show up here on the AFE?
That's correct.
Yeah, but you'll make sure that Mr. Doak, whoever happens to run those economics, gets that information.
Yes, yeah, we take a look at what our average drill and complete costs are throughout the basin. We'll take a look at what type of well are being drilled. So for example, in this one, the 2.5 mile wells. So there's that calculation to figure, okay, what's it cost to drill something that might be slightly longer? And then that's what we projected including those economics.
Okay, very well. But commissioners, any other questions? So Wildgrass, did we ask all the questions that you wanted to ask? And if not,
I have one more question.
very well.
Okay, thank you. Extraction has now testified that they do account for the costs of the project based on historical and other data not pertaining particularly to this project. But they've also testified that this project is unique in its heightened level of protection for public health, safety, and welfare. So how does extraction account for the difference in cost? If they're only using historical numbers for other projects that are in rural areas and don't have things like the BMP, how do they account for that in their economics?
I can answer that. So this is a unique project in that you're right, that we've done these BMPs in a number of places, but we haven't done all these BMPs at one specific location. So we'll take a look at, for example, what does it cost for electric drilling? We might be in some place in county where there's not an EDR that's being used, but we have an EDR rig, electric drilling rig in another location, so we know what those costs are, and so we can apply that here. Whether it might be sound walls. We don't do sound walls everywhere, but where we do them, we do all those costs, and so we can apply that here. Where we have locations with pipelines, we know what those costs are for those facilities, so we can take that best management project and we know what those costs are for this Broomfield project. So just because we haven't put all these BMPs in one spot doesn't mean we don't have an understanding of what those costs are, because we have employed them throughout the basin, and they're going to be employed here, and those costs have been included on the project economics, and it's still economic.
We don't have any further questions.
Okay, so Mr. Newhall, do you agree with Mr. Doak's testimony that you added $300,000 per well to comply with the BMPs for this? And that you also increased the operating expenses a minimum of $5,000 a month for additional BMP compliance?
That is correct.
Thank you. Yes, Commissioner Ager.
And so just to make sure I'm clear on the differences, but those costs would not be on this AFE.
No, some of those costs would be, like for electric drilling rigs, so when you go to the drilling side, or for example, the completions. We had planned to use the quiet completions fleet here, which uses a dual fuel system. And so we take a look at what that cost is, and that is included on this AFE.
So only the BMPs that are associated with drilling the well, not operating well.
Correct.
Thank you.
All right. Any other questions? Thank you. Mr. Pachala.
Extraction has no further witnesses for its case in chief.
And how much time do we have left for each party?
Yes, extraction has 26 minutes and 20 seconds, and Wildgrass has 34 minutes and 29 seconds.
You're finished with your case in chief.
We're finished with our case in chief.
All right. Would it be acceptable to Wildgrass if we broke for lunch and then took your case up after lunch?
That'd be fine.
Very well. How long did we have scheduled for lunch today? Ms. Larson?
We had that we would return at 1:30 to begin this afternoon's hearing on the comport issue. So we have yet, obviously, to complete this matter. I don't know if you wish to have an abbreviated lunch in order to accommodate.
I think perhaps at 1 p.m. We're going 45 minutes. Time to rush out, grab a sandwich, come back. We'll reconvene at 1 p.m. Thank you. Sometimes it's